You could be asked to wire up to $15,000 before the United States even approves your next tourist or business visa. And if you carry a Malawian or Zambian passport, one embassy interview next month could trigger the debit alert. Miss this rule and you risk forfeiting the bond, facing a 3-year re-entry bar, and watching future green card plans just completely collapse. In the next few minutes, I'll share with you exactly how this new $15,000 bond pilot works and who must pay and the fastest way to protect your money and your travel plans. Hi, I'm Zaira Solano, founder of Solano Immigration Law Firm, where I've practiced for the last 14 years. And let me dive right into this. I'm seeing so many questions about this new pilot program from the State Department that would require some visa applicants to post a bond of up to $15,000 just to enter the United States on a tourist or business visa. As an immigration attorney who's handled hundreds and hundreds of these cases, I want to break it down for you step by step so that you understand what's really going on and how it might affect you or someone you know. This program is officially a 12-month pilot running from August 20th, 2025 through August 5th, 2026, and it's aimed at certain foreign nationals applying for B1 business visas or B2 tourist visas. The idea is to make sure that people don't overstay their welcome in the United States. If you're from a country with a high overstay rate, meaning more than 10% of visitors from that country stick around here in the United States for longer than allowed, you might have to put up this refundable bond as a condition for getting your visa approved. Right now, it's starting with nationals from Malawi and Zambia, based on the data from the Department of Homeland Security's fiscal 2023 overstay report. But here's the thing, the list could change. The State Department can add or remove countries during the pilot program if overstay rates shift or if diplomatic pressures come into play. For example, countries like Chad or Laos have been mentioned in reports for having even higher rates, so we might see expansions there. The bond amounts are set at $5,000, $10,000, and $15,000, and it's the consular officer at your visa interview to decide which one applies to you. They'll look at things like your job back home, your income, your education, and your reason for your trip to the United States. It's not arbitrary, but it's definitely discretionary, which means it's based on their assessment of whether you're likely to return home after visiting the United States. How does this bond process actually work in practice? Well, let's talk about that. Let's talk about the nuts and bolts of how this actually plays out. You're applying for your B1, B2 visa. You go to your interview at the U.S. Embassy or consulate abroad, and everything checks out for you. You've got ties to your home country, you have your itinerary of coming and returning, and all that. But if you're from one of these targeted countries, the officer might say, okay, you're eligible for this visa, but you need to post a bond first. You'll get directed to fill out DHS form I-352, which is the immigration bond form, and then you'll have to pay through the U.S. Treasury's Pay.gov site. The U.S. government will give you a specific link. Don't go paying on some third-party website because the government won't honor that and you won't get your money back even if you become victim to a scam. It's crucial to wait for the official go-ahead before you jump the gun because it could cost you. Once you pay and the visa is issued, you must enter the United States and leave through specific airports. Those include Boston Logan, JFK in New York, or Dulles in Washington, D.C. Why? Because those ports are set up to properly record your entry and exit, which ties directly to whether you get your bond money back. If you fly into somewhere else, you might get turned away or have issues with your departure being logged correctly. The bond is refundable if you play by the rules, which means you need to leave on time and you don't overstay by a day and you don't try to change your status while you're here, like filing for asylum or adjustment to a green card or anything else. Overstaying is a big deal. And in fiscal year 2023, over 500,000 did that. And that's why the government is rolling out this program because they're trying to stop overstays. But if you do overstay, the Department of Homeland Security will review your case. And if there's a breach, that money will be forfeited completely to the government. You will never get it back. And you can also face removal proceedings under Section 237A1B of the Immigration and Nationality Act, which makes overstaying a ground of deportation. I've seen clients in similar situations where a simple overstay led to a 3-year bar from reentering the United States under INA Section 212A9B, or even 10 years if it was longer than a year. It's not just losing the bond, it can derail your future immigration plans. Let me give you a real-world example to illustrate. Think about a case like Matter of Healy and Goodchild, decided by the Board of Immigration Appeals back in 1997. There, the respondents posted bonds for their release from immigration detention. But when they didn't comply with departure orders, those bonds breached. It's not the exact same thing as the visa bond, but the principle is similar. The government uses financial incentives to ensure compliance, and forfeiture happens when you don't hold up your end of the deal. Who does this affect, and what are their expectations? Right now, this isn't going to hit everyone. If you're from a visa waiver program country like the UK or Japan, you're probably fine. No bond required. And even for B1, B2 applicants from other countries, it's only if your country hits that high overstay threshold. But if you're dual national or using a passport from Malawi or Zambia, even if you live elsewhere, this could apply to you. What about families or groups? Each person has to post their own bond. So if you're traveling with kids or a spouse, that adds up very quickly. And no, there aren't explicit exceptions listed in the rule for things like medical emergencies or students. It's focused on these visitor visas specifically. I've had clients ask if this discriminates against poorer countries, and honestly, it does target them based on data. But the State Department frames this pilot program as a diplomatic tool to push those governments to improve their own screening and document security. For instance, citizenship by investment programs in the Caribbean, where you can buy citizenship through much vetting, might come under scrutiny if overstays rise there. We've seen similar pressures in the past with the visa waiver program reviews under INA Section 217, where countries get dropped if they don't meet security standards. One case that comes to mind is Kerry versus Din from 2015, where the Supreme Court upheld the government's broad discretion in visa denials, even without detailed explanations. It underscores how much power consular officers have, which extends to decisions like bond amounts. If you're denied because you can't afford the bond, it might feel unfair. But challenging that is even tougher. Consular decisions are rarely reviewable in court. Overstaying isn't just about losing money, it can snowball into bigger problems. And if you forfeit that bond, that's 15 grand gone that you'll never get back. But then you're also accruing unlawful presence in the United States. Under INA Section 212A9B, if you're here unlawfully for more than 180 days, you trigger a 3-year bar. If you're here for more than 1 year, you trigger a 10-year bar. That means even if you leave voluntarily, after forfeiting your bond and not getting your money back, you can't even come back for that period of time without a waiver, which isn't easy to get, and many people don't qualify for a waiver. If you try to adjust status while you're here, like marrying a U.S. citizen and filing for a green card, that could be seen as a breach too, leading to forfeiture of your bond. I've represented folks in removal proceedings where an overstay complicated everything. Take the case of Patel versus Garland from 2022. The Supreme Court limited federal review of USCIS decisions on adjustment of status, but it highlights how past violations, like overstays, can hunt you later down the road in other applications. Plus, there's the deportation risk. If DHS catches you here, you might end up in proceedings under the Executive Office for Immigration Review, which is the immigration court, and getting a bond while detained by immigration can be much higher than what you've already paid. I've seen them go up to $20,000 or more for a release pending a future hearing. The key is prevention. Plan your trip carefully. Keep proof of your ties back home. And if something changes, consult an immigration attorney before you're required to depart. This pilot revives an idea from the first Trump administration in 2020, which got sidelined by COVID. But now it's tied to an executive order called Protecting the American People Against Invasion, emphasizing immigration security as an issue. The goal is deterrence, making overstay costly enough that people think twice. But it's also about international relations. By targeting specific countries, the United States is signaling, hey, get your overstay rates down or your citizens pay the price. We've seen this before with the reciprocal visa fees under INA Section 281, where if a country charges us high fees, we do the same back. Critics worry it'll hurt tourism and business ties, especially with events like the 2028 Olympics coming up. Legitimate travelers might skip the U.S. altogether if they can't swing the bond. On the flip side, supporters point out that over 500,000 overstays in 2023 as justification. It's a targeted fix, not a blanket policy. In my practice, I've seen how these shifts affect real people. For example, in the case of Sale versus Haitian Centers Council from 1993, the Supreme Court allowed interdiction of refugees at sea, showing the government wide latitude in entry controls. While not directly related, it illustrates the authority behind programs like the Bond Pilot. What should you do if this affects your visa plans? First off, don't panic. If you're planning a trip and might be impacted, check the State Department's website for the latest list of countries. Prepare strong evidence for your interview. Bank account statements, property deeds, employment verification letters, anything that shows that you are going to return home. If you can't afford the bond, explore alternatives like applying for a different visa category if it fits you, or even consider travel to visa-free countries for the U.S. if eligible. But remember, this is a pilot. It might expand, it might contract, or it might end based on the results that the government sees. I've helped clients navigate similar hurdles by filing waivers or appeals when possible. For instance, under INA Section 212D3, there's a waiver for non-immigrant visa eligibilities, but it's discretionary and not automatic for bonds. It's usually referred to as the hanker waiver. The best empowerment comes from knowledge. Understand your rights, document everything, and if in doubt, always talk to an experienced immigration attorney. Overstays can lead to complications down the line, like in naturalization applications where good moral character is assessed under INA Section 316. Looking ahead, if the pilot succeeds in dropping overstay rates, we could see it become permanent or expand to more countries. Data from Homeland Security shows overstays are a bigger source of unlawful presence than border crossings in some years. So enforcement here makes sense from a policy view. But for individuals, that means planning farther ahead. Businesses relying on international visitors might push back, citing economic hits. Tourism brings in millions annually. And for families separated by oceans, this adds layer of bureaucracy. One historical parallel is the Chinese Exclusion Act. Cases from the late 1800s, like Che Chan-ping versus the United States in 1889, where the court upheld Congress's plenary power over immigration. It reminds us that while policies change, the government's authority is broad. So staying informed is key to protecting your options. In my experience, clients who act proactively, like renewing visas early or seeking extensions under INA Section 248, fare much better than those who wait until problems arise. Wrapping this up, we've covered the basics of the new visa bond pilot, who it targets, and how it works, and the risks of non-compliance, in addition to its place in bigger immigration trends. It's a tool to reduce overstays, but it requires careful navigation if it applies to you. If you're dealing with immigration challenges, especially something like qualifying for protection while working legally, you don't want to miss out on my next video, the U visa, and how to work and secure your green card safely. It's packed with steps to build a strong case without risking deportation, and in today's immigration climate, knowing that this could be crucial to safeguarding your future in the United States. Head over to watch it right now. It's essential for anyone exploring these options. See you there.